Have you ever really stopped to think about how a country manages its borders? You know, those invisible lines? Who gets to cross them? Who gets to stay, maybe build a life? Or even who gets to leave? These aren't just abstract legal ideas. They affect real people, millions of them, and they go right to the heart of what makes a country a country. So today, we're taking a deep dive into a really key piece of this puzzle, the Immigration Act of 2002. Now, when we say Act of 2002, it's important to understand this is what's called a consolidated act.
That's right. Think of it like the original law, but with all the changes, all the updates since then, woven right in.
So it's not some dusty old document.
Not at all. It's a living thing, constantly being tweaked to deal with, well, new situations. And our job today really is to make this pretty crucial legislation understandable. Whether you're just, curious about how immigration actually works day to day, or maybe you're a law student trying to get your head around the details.
Yeah, we want to unpack its main purpose, look at the key rules, the sort of legal background, how it works in practice, and what it actually means out there in the real world.
Exactly. Using clear language where we can, but also, pointing out those specific legal terms that really matter.
So think of this deep dive as your shortcut. We'll try to give you those interesting bits, those aha moments, hopefully without drowning you in legal jargon.
Yeah.
We're bringing the core ideas to you. Okay, let's start at the beginning. The foundation. This act was officially signed into law by the president back on May 30th, 2002.
And it mostly came into effect, kicked into gear on March 12, 2003.
But like you said, it's not static.
Definitely not. It's been updated constantly. The latest changes were folded in as recently as December 11, 2024, and it was last reviewed just this March 28, 2025.
That constant updating really shows how active and relevant it is, doesn't it?
It does. And its core purpose, the main text spells it out pretty directly, to provide for the regulation of admission of persons to their residence in and their departure from the Republic, and for matters connected therewith.
Okay, regulation of entry, stay, and exit. Seems clear enough.
It is, but to really get the spirit behind it, the why, you've got to look at the preamble. That's where the vision is laid out. The preamble talks about creating a new immigration system, and it's built on some really important pillars. First, efficiency. It says visas and permanent residence permits should be issued as expeditiously as possible.
So, faster processing.
Ideally, yes, based on simplified procedures and objective, predictable, and reasonable requirements. Then there's a big focus on security and control. The state needs to manage immigration and satisfy security needs.
Makes sense. What else?
Well, maybe surprisingly for some, it explicitly aims to boost economic growth. Things like getting needed foreign labor, encouraging foreign investment, attracting highly skilled people, even promoting tourism. It's right there in the goals.
That's interesting, the economic driver aspect.
And crucially, there's a strong commitment to human rights. Talks about immigration control within the highest applicable standards of human rights protection. It even mentions preventing xenophobia and educating people about the rights of foreigners and refugees.
So efficiency, security, economy, and human rights. That's quite a balancing act.
It absolutely is. And finally, it acknowledges the country's role in the region and internationally, making sure it complies with its global obligations. So it's trying to be efficient, secure, good for the economy, and humane.
That sets a high bar. Now, speaking of the legal details, there's something quite important for anyone actually reading the law or older documents, right? A change in wording.
Yes, exactly. A big amendment back in 2011, Act 13 of 2011. It fundamentally shifted some key terms. The word permit, when talking about temporary stays, was largely swapped out for visa.
So what used to be a temporary residence permit is now just called a visa.
Pretty much. And condition often became terms and conditions. So if you're looking at older case law or documents, you'll see permit everywhere. But the current law, the consolidated version we're discussing, uses visa for those temporary stays.
That's a really useful detail to know. Highlights how the law evolves. Okay, so how is this massive act actually managed? Who makes the decisions?
Well, it sets up something called the Immigration Advisory Board. This isn't just a formality. It's meant to provide real input and oversight.
And who's on this board? Is it just government officials?
No, and that's quite interesting. You have key government figures like the Director General of Home Affairs, the head of Immigration Services, but it also specifically includes someone representing organized business and someone from organized labor.
Ah, so bringing in those economic stakeholders directly.
Exactly. Plus, up to 5 individual experts in things like immigration law or control. So the idea is definitely to get broad consultation, not just an internal government view.
So what does this board actually do?
Its main job is advising the minister on pretty much everything, drafting specific rules, shaping overall immigration policy. It also acts as a forum for different government departments to cooperate. It really pushes for a collaborative approach.
Okay, so the board advises, but the minister still has a lot of power.
Oh, absolutely. The minister has broad powers to make regulations. Think of these as the nitty-gritty instructions, how the act actually works on the ground.
So the detailed stuff, like application forms, fees.
Exactly. Regulations cover immigration officers' duties, rules to prevent illegal entry, the specific requirements for every type of visa, the fees involved, though the finance minister usually has to agree on those, even the exact forms you fill out. This is where the law hits the street, so to speak.
Right, where the rubber meets the road. And what if something goes wrong? What if the decision feels unfair?
That's crucial. The Act builds in review and appeal procedures. If an immigration officer at the border refuses you entry or says you're an illegal foreigner, you have the right to ask the minister to review that decision.
Is there a time limit?
Yes, and sometimes it's very tight. If you're being refused entry and, say, the plane or ship you arrived on is about to leave, you might only have 3 days to request that review. For other decisions that negatively affect your rights, there's usually a two-step appeal process. First to the Director General, then, if needed, to the minister.
How long do you get for those appeals?
Typically 10 working days for each step. It's a really important part of ensuring due process and protecting people's rights within the system. It provides those checks and balances.
Okay, that sounds like a system designed, at least in theory, for fairness.
Yeah.
So let's get to the core process, actually entering, staying, and leaving. How does that work?
Well, the basic rule is pretty clear. If you want to enter or leave the Republic, you generally have to do it at a designated port of entry, an official border post, airport, or harbor.
No, just wandering across the border somewhere.
Legally, no. For citizens, it's mainly about proving who you are. For foreigners, you need a valid passport. And unless you happen to be a permanent resident already, you also need a valid visa that matches your reason for entering.
So a visa is usually essential for foreigners.
Almost always for entry, yes.
Yeah.
And for staying temporarily, the Act lays out a whole range of temporary visas. Each one is for a specific purpose. This is really key.
Meaning you can't just get one visa and then decide to do something else?
Generally, no. You need the visa that covers your actual activity. For instance, there's the visitor's visa. This is kind of the default for purposes not covered by other specific visas like tourism or visiting family.
How long does that usually last?
Typically up to 3 months initially, though it can sometimes be renewed. But the big thing here is that holders of a visitor's visa may not conduct work unless it's specifically allowed in very limited prescribed circumstances.
Okay, so visitors visit, they don't work. What else?
Then you have specific ones like a study visa if you're coming to study at an approved institution. There are various work visas.
Oh, work visas. Are there different kinds?
Yes. There's a general work visa, which often requires proving a South African couldn't fill the role. Then there's the critical skills work visa for professions the government identifies as being in short supply. The minister publishes a list. And an intra-company transfer work visa for employees moving within a multinational company.
What about starting a business?
That's the business visa. But it comes with strings attached. You usually need to invest a certain minimum amount of capital, and you have to promise to employ a certain number or percentage of South African citizens or permanent residents within a year.
So it's aimed at serious investment and job creation.
Exactly. The minister can even declare certain types of businesses as undesirable, meaning you couldn't get a visa for them.
Wow, okay. Any other notable temporary visas?
Yeah, quite a few, actually. There are visas related to specific treaties, visas for ship or aircraft crew, medical treatment visas, again, no work allowed on that one. There's a relatives visa for joining family, but the citizen or permanent resident relative usually needs to provide financial assurance, and the visa holder can't work.
So many specific categories.
Definitely. There's also a retired person visa based on proving you have sufficient income, like a pension or enough net worth. Work might be authorized sometimes on that one. There's a corporate visa for companies bringing in groups of foreign workers with limits and guarantees needed, an exchange visa for specific cultural or economic programs, and even an asylum transit visa.
What's that last one?
It's a very short-term, 5-day visa, just to allow someone seeking asylum to travel legally to a designated refugee reception office to make their claim. It's purely for transit.
That's incredibly detailed, covering almost every reason someone might come temporarily.
That's the idea, a specific legal box for each purpose.
Okay, so that's temporary stays. What if someone wants to make the Republic their permanent home?
Then we're talking about permanent residence. Getting a permanent residence permit is a big deal. It basically grants you almost all the same rights, privileges, duties, and obligations as a citizen.
Almost all. What's excluded?
Things explicitly tied only to citizenship by law or the Constitution, like typically the right to vote in national elections or hold certain high public offices. But otherwise, it's very close to citizenship status in daily life.
How do you qualify for that?
There are a few main routes. One is based on work. If you've held a valid work visa for 5 continuous years and you have an offer for permanent employment in a suitable job, you can apply.
So, long-term contribution through work, what about family?
Yes, family is another major path. If you're the spouse of a citizen or a permanent resident, you can apply after 5 years, but you have to prove it's a genuine, good-faith spousal relationship.
Good faith. Is there a check on that?
Yes, there's a significant catch. If the relationship ends other than through death within 2 years of getting the permit usually lapses. It's designed to prevent marriages purely for immigration purposes.
That's a strong measure. What about children?
A child under 21 of a citizen or permanent resident can also apply for permanent residence. They usually need to confirm their status again when they turn 18.
Okay, work and close family ties. Are there other ways?
Yes. Section 27 outlines other grounds. People with extraordinary skills or qualifications, or making a significant business investment, similar requirements to the business visa, involving capital and job creation. Again, if you don't maintain the business investment as required, the permit can lapse.
So, conditions can apply even after getting it?
Absolutely. Refugees who've been formally recognized can also apply for permanent residence. And finally, individuals who can demonstrate they have a certain prescribed minimum net worth.
But you mentioned conditions. Can permanent residence be taken away? I thought it was permanent.
It's intended to be permanent, but yes, it can be withdrawn by the Director General under certain circumstances.
Like what?
Serious criminal convictions are a big one. The Act has detailed schedules listing relevant offenses. Also, if you fail to comply with any specific terms or conditions attached to your permit, or, significantly, if you're absent from the Republic for more than 3 years without getting prior permission from the department.
So you can't just get it and disappear for years.
Exactly. It implies an ongoing connection to the country.
Okay. Now, the Act doesn't just talk about who can come, it also talks about who can't, right? These categories of prohibited and undesirable persons.
Yes, and the distinction is important. Prohibited persons under Section 29 are basically people who are automatically barred. They simply do not qualify for any visa or admission. It's hard stop.
Who falls into that category?
It includes people with certain prescribed infectious diseases that pose a public health risk.
Yeah.
People with outstanding arrest warrants or serious convictions for crimes like genocide, terrorism, human smuggling, trafficking, murder, serious drug offenses, money laundering, kidnapping.
Yeah.
The list is quite specific.
So serious criminality or health risks.
Right. Also, using fraudulent documents to try and enter, or having been deported before and not having gone through a formal rehabilitation process, and being associated with organizations that promote racial hatred or use crime or terrorism. If you're found to fall into one of these categories, even if you were issued a visa before, that visa has to be withdrawn.
Okay, that's prohibited. What about undesirable persons under Section 30? How is that different?
Undesirable persons aren't automatically barred, but they can be declared undesirable by the Director General. It's more of a discretionary decision based on certain factors.
What kind of factors?
Someone likely to become a public charge, meaning they might end up relying on social welfare. Someone who's been judicially declared incompetent. An unrehabilitated insolvent, basically, someone bankrupt who hasn't legally resolved it.
So, financial or legal competency issues.
Yes. Also, fugitives from justice. People with previous criminal convictions for offenses, that would also be crimes here, where they didn't get the option of just paying a fine. And here's a really practical one. People who have overstayed their visa the prescribed number of times. Repeatedly overstaying can lead to being declared undesirable.
That's a key takeaway. For anyone on a temporary visa, overstaying has serious consequences beyond just having to leave.
Absolutely. Can bar you from returning.
Now, you said declared undesirable, suggesting discretion. Is there any flexibility with these categories? Prohibited seems very final.
Well, interestingly, even with these strong prohibitions, there's an element of discretion built in. For prohibited persons, the Director General can waive the grounds for good cause. For undesirable persons, the minister can waive the grounds, again, for good cause.
Good cause. That sounds quite broad.
It is. And it allows for flexibility in specific cases. Another example of ministerial discretion is Section 312B, which allows the minister to grant permanent residence rights due to special circumstances.
Has that been used recently?
Yes,
Yeah.
it's highly relevant. This discretion is likely the basis for the recent decisions to extend the validity of the Zimbabwean exemption permits, ZEP, and the Lesotho exemption permits, LEP, until November 28, 2025. This shows the Act adapting to wider regional situations or humanitarian needs.
That's a fascinating example of how these legal mechanisms play out in real life, responding to complex situations. Okay, so what happens if someone is found in the country without the right visa or permit? An illegal foreigner.
The Act, in Section 32, is very direct about this. An illegal foreigner shall depart, unless they get specific authorization to stay, while, say, an application for a valid status is pending. But the fundamental rule is, they shall be deported.
And who enforces this?
This brings us to the Inspectorate, established under Section 33. This is a dedicated body within Home Affairs, including immigration officers. They have significant powers to investigate potential contraventions of the Act, conduct inspections, demand documents, and question people.
What about their powers to enter places or arrest people? What are the rules around that, and what about people's rights?
It's a careful balance, as you say. Immigration officers can get warrants from a magistrate to enter and search premises or to apprehend someone believed to be an illegal foreigner.
So normally a warrant is needed.
Normally, yes. However, they can also act without a warrant to enter and search premises, excluding private homes under specific conditions. For example, if they get consent from the owner or person in charge. Or, crucially, if they reasonably believe a warrant would be issued if they applied, but the delay caused by getting it would defeat the purpose of the search, like if evidence might be destroyed.
That sounds like a significant power. Are there safeguards?
Yes, the Act explicitly states these actions must be conducted with strict regard to decency and order. It specifically mentions respecting the person's dignity, freedom, security, and personal privacy. So the power exists, but is meant to be exercised respectfully.
Okay. And if someone is arrested for deportation, what happens then? We hear a lot about deportation and detention.
Right. Section 34 deals with this. An immigration officer can arrest an illegal foreigner without needing a warrant specifically for the arrest itself, and then proceed with deportation. But again, there are important safeguards built in. The person must be notified in writing about the decision to deport them, and informed of their right to request that review or appeal we talked about earlier. If they're detained, they have the right within 48 hours to ask for a court warrant confirming the detention. If the court doesn't issue that warrant confirming the detention is lawful, they must be released.
So judicial oversight kicks in quickly.
Yes. They also must be informed of all these rights in a language they understand. And detention just for the purpose of deportation can't exceed 30 calendar days unless a court issues a warrant extending it. That extension itself can only be for a maximum of another 90 days.
So there are time limits on detention pending deportation.
Absolutely. And crucially, the conditions of detention must meet minimum prescribed standards protecting his or her dignity and relevant human rights. There was actually a constitutional court order about these standards in March 2024, reinforcing their importance. So while deportation is a legal consequence, the process is meant to uphold fundamental rights.
This deep dive really shows that managing immigration isn't solely the government's task. It seems like the Act places responsibilities on many different people and organizations.
That's a very important point. It outlines duties and obligations for a wide range of stakeholders. It's definitely seen as a shared responsibility.
Like who? Who else has duties under this Act?
Well, employers have significant obligations under Section 98. You cannot employ an illegal foreigner, period. Nor can you employ a foreigner in a job that their visa doesn't authorize them to do.
What does an employer need to do?
They must make good faith efforts to check the person's status before hiring them, asking for passports, visas, permits, and they have to keep records of the documents they checked for 2 years after the employment ends. There are even legal presumptions that make it harder for employers to claim they didn't know, and penalties get steeper for repeat offenses.
So the onus is really on the employer to check carefully.
Definitely. Learning institutions have similar duties under Section 39 regarding enrolling foreigners for training or instruction. They need to ensure their students have the correct visas, usually study visas.
What about places like hotels or guest houses?
Certain classes of accommodation providers, Section 40, are required to keep registers of all their lodgers, including details that could help identify their status.
And transport companies, airlines, buses.
Conveyance operators, Section 35, have extensive duties. Owners or captains of ships, pilots of aircraft, drivers in charge of vehicles crossing borders, they have to electronically send passenger information in advance. That's Advanced Passenger Processing, APP, and Passenger Name Records, PNR.
So pre-screening passengers before they even arrive.
Exactly. They also have a duty to ensure passengers actually have the valid passports and visas needed for entry before boarding them. And if someone they transport is refused entry, the conveyance operator is generally responsible for detaining them and paying the costs of removing them from the country.
That's a heavy responsibility for carriers.
It is. And it doesn't stop there. Even organs of state, other government departments, and certain other institutions have duties under Sections 44 and 45. They have to try and ascertain the status of people they serve or transact with and report suspected illegal foreigners to Home Affairs.
But wait, does that mean, say, a public hospital could refuse emergency treatment to someone they think might be an illegal foreigner?
No, and this is a critical human rights balance written into the Act. That duty to report cannot prevent them from providing services that illegal foreigners or foreigners are entitled to under the Constitution or any other law. Access to basic rights like emergency health care, basic education for children, those are protected regardless of status.
That's a really important distinction. So reporting duty, yes. Denial of fundamental rights, no.
Precisely. And perhaps one of the broadest sections impacting everyday people and businesses is Section 42, aiding and abetting illegal foreigners.
What does that cover?
It's very wide-ranging. It basically prohibits anyone from doing anything that helps an illegal foreigner remain in the country, or helps any foreigner violate the terms of their visa. The only exception is for providing necessary humanitarian assistance.
So what kind of help is prohibited?
Things like providing instruction or training, issuing licenses, entering into business agreements, conducting any business transaction, providing accommodation, whether renting or just letting someone stay, or even letting or selling property to them.
Wow, that covers a lot of ground. Renting an apartment, hiring someone for casual work, even selling them something significant.
Potentially, yes, if you know or should know they are an illegal foreigner or violating their status. The Act specifically says it's no defense to claim you didn't know if you ought reasonably to have known their status.
That ought reasonably to have known part puts a significant burden on ordinary people and businesses, doesn't it? To basically verify status in many interactions.
It absolutely does. It makes immigration compliance a very broad societal responsibility under the law.
Okay, so the Act sets out all these rules, assigns duties. What happens if people break these rules? What are the consequences?
Well, the Act doesn't just rely on goodwill. It backs everything up with serious offenses under Section 49 and also administrative offenses under Section 50 for less severe, often negligent, breaches.
How serious are we talking? Fines? Jail time?
Both. The penalties can be quite severe, reflecting the seriousness with which compliance is viewed. For example, just entering, staying, or leaving unlawfully can get you up to 2 years in prison. Failing to depart when officially ordered to leave could mean up to 4 years.
What about helping someone enter or stay illegally? That aiding and abetting.
Assisting unlawful entry or stay carries a penalty of up to 5 years imprisonment.
And employing an illegal foreigner. You mentioned escalating penalties.
Yes. For a first offense, it could be up to 1 year. But for a third or subsequent conviction, it jumps to potentially 5 years without the option of a fine. That's a very strong deterrent for employers.
What about corruption? Public officials involved.
The penalties there are particularly harsh. A public servant involved in misconduct, like providing fake documents or taking bribes related to the act, faces up to 8 years. If that public servant works for the Department of Home Affairs itself, the potential penalty is even higher, up to 15 years, again, without the option of a fine.
15 years, no fine option. That sends a very clear message about internal corruption.
It certainly does. Conspiracy to break the act can lead to 7 years, or 8 if it's an international conspiracy. And then there's a whole range of offenses related to fraud.
Like using fake passports.
Exactly. Fraudulent acts, making false statements, impersonating an immigration officer, possessing fake stamps or documents, using false documents, even destroying someone else's travel document to help commit a crime. These can all lead to imprisonment for up to 15 years without the option of a fine.
So the Act treats immigration-related fraud extremely seriously, almost on par with corruption within the department.
Yes. It shows a strong commitment to protecting the integrity of the immigration system and tackling the criminal activities often associated with it, like human trafficking or smuggling.
Are there less severe penalties, too? You mentioned administrative offenses.
Right. Section 50 allows for administrative fines to be imposed for certain actions that might be seen as negligent rather than criminal intent. Things like an employer making an incorrect certification about a foreign employee or a conveyance operator failing to comply with some of their duties. It provides a lower level enforcement mechanism as well.
Wow. Okay. What an incredibly detailed and frankly complex piece of legislation. This deep dive into the Immigration Act of 2002, it's covered so much from its really broad aims, trying to boost the economy and protect human rights through to all the specific types of visas, the rules for permanent residency, and then these very strict enforcement measures and penalties. It's clear this act really does shape who can enter, stay, work, and leave the Republic.
Absolutely. I think we've really seen how it tries to perform that difficult balancing act between the state's need for control and security and the crucial importance of protecting individual human rights.
And how it's not static, right?
Definitely not. It's constantly being amended, updated. And that element of ministerial discretion we discussed, allowing for things like the ZEP and LEP extensions, shows it can adapt, albeit sometimes controversially, to changing realities. It really highlights that immigration law is almost never set in stone.
This has really illuminated that intricate dance between the high-level policy goals, the detailed legal framework, and how it all impacts everyday life for so many people, citizens, residents, visitors, employers, everyone. Thinking about everything we've covered, what really stands out to you?
For me, it's probably the sheer breadth of it, but also that inherent tension we kept seeing. The push for efficiency versus the need for due process, the drive for economic benefit versus the imperative of human rights, and the way responsibility is spread so widely. So maybe a final thought to leave everyone with. Considering how complex this law is, how constantly it seems to evolve, and how deeply it affects people's lives, how can we as individuals, as businesses, as a society, best navigate these rules to ensure we are compliant? Yes, but also always upholding those fundamental human rights the Act itself acknowledges.